Hello everyone, this is Aboorva, a legal intern in Lexcliq company. For today, I'm going to be talking about joint tortfeasors and loss in India. So, when two or more persons unite to cause damage to another person, then they will be liable as joint tortfeasors. So, all those who actively participate in the civil wrong commission are joint tortfeasors. So, based on the percentage of damage caused by his negligent act, each joint tortfeasor is responsible for paying a portion of the compensation granted to the complainant. So, according to the principle of contribution, the defendant who pays more than his share of the damages or who pays more than he is at fault may bring an action to recover from the other defendants. So, now let me tell you about the liability of joint tortfeasors. So, when two or more persons join together for common action, then all the persons are jointly and severally liable for any tort committed in the course of such action. So, there were three principles in English common law with regard to the liability of joint tortfeasors. They are: the first principle is that the liability of wrongdoers is joint and several. That is, each is liable for the whole damage. The person may sue them jointly and separately. The second principle was laid down in the case of Brinsmith versus Harrison, where it was held that a judgment obtained against one joint wrongdoer released all the others even though it was not satisfied. So the third rule was laid in the case of Merriweather versus Nixon, where it was held that in common law no action for contribution could be sustained by one wrongdoer against another, although one who sought a contribution might have been compelled to pay the full damages. So the reason alleged for this rule was that any such claim to the contribution must be based on an implied contract between tortfeasors, and that such a contract was illegally concluded with the view of committing an illegal act. But the above mentioned rules were virtually abolished by the Law Reforms Act 1935 and the Civil Liability Act 1978. Then the laws in India, where in India there is no statutory law on joint tortfeasors liability. As stated above, in England the Law Reform Act 1935 and the Civil Liability Act 1978 have virtually brought the position of joint tortfeasors on par with the independent tortfeasors. So the question therefore arises: should the Indian courts follow the common law on joint tortfeasors, which was laid down in Brinsmith and Merriweather cases and was prevailing in England prior to 1935, or the law enacted by the British Parliament is in 1935 and 1978. So, up to 1942, the courts in India had followed the laws as laid down in the Brinsmith and Merriweather case, but in some cases, the courts expressed doubt about its applicability in India. The Supreme Court of India in Kushro S. Gandhi versus Guzdar refused to follow the common law of England. The fact was that in the suit for damages for defamation, one of the defendants had tendered an apology to the plaintiff, and the court has passed a compromise decree between the plaintiff and the defendants who tendered an apology. So, when the plaintiff wanted to continue the suit against the other defendants, it was contended by the defendants that the compromise decree released all other defendants from their liability. Rejecting the contentions of the defendants, the court held that in the case of joint tortfeasors, in order to release all joint tortfeasors, the plaintiff must receive full satisfaction, or which the law must consider as such from a tortfeasor before other joint tortfeasors can rely on accord and satisfaction. So the rule, which is in consonance with justice, equity and other and good conscience, will convince only that type of liability of tortfeasors as joint and several. So in the light of above decision, the recent trend of the Indian court is to follow or adopt common law of England or the law enacted by the British Parliament if it is in the consonance with the principles of equity, justice and good conscience under the Indian Constitution. So now, let me tell you about the criticism of joint tortfeasors. So, joint and multiple liability doctrine is criticized because it it can result in severe inequities. For example, a defendant who has only 10% responsibility for an accident that is jointly and severally liable with a defendant who is 90% at fault for an accident may have to bear the full amount of damage, financial burden, even though his or her mistake was quite minor. So, joint and multiple liabilities is a system that protects the complainants when one or more wrongdoers are unable to pay damages owed to the complainant. However, this can lead to disproportionate and unexpected results for tortfeasors. So, that's it for today, everyone. If you like my video, please subscribe to this channel. You will be updated with our new videos and new informations. Thank you.